Hello, I'm Chris Merritt, and I'm joined today by Barrister Louise Clegg. We're here to discuss the referendum to change the Constitution and establish an Indigenous voice to Parliament. Public support for this proposal has been declining ever since it was unveiled at the Garma Festival last July, without involvement of the broader community and without legal advice from the Solicitor General, Stephen Donoghue. The latest news poll released just this week shows that slide is continuing, which suggests unless something changes, this referendum is heading either for defeat or for a narrow victory. Both those outcomes would be a disaster. They would confirm that the push for this form of constitutional recognition of Indigenous Australians has divided the nation, which is the reverse of what this project was supposed to achieve. So what's to be done? This is where Miss Clegg might add some answers. First, Louise, tell us a little bit about yourself and what might be driving this slide in support for the Garma provision.
Oh, well, look, I'm a lawyer. I started out my career in a national law firm where I worked as a solicitor for 7 years, and then I went to the New South Wales Bar and I practiced there pretty much full time for about 11 years. I've done a bit of teaching at a group of 8 universities, undergraduate teaching of law subjects, including public law and constitutional law. But I guess where I'm a little bit different to most lawyers is that I now live in Goulburn, and I practice differently, very differently to how I used to. And so I think what I bring to this debate is a bit of knowledge of public law and constitutional law, but also I do live in, and I also happen to grow up in Middle Australia. And I think that's why I'm a little bit exasperated, perhaps more exasperated than your average public lawyer, because I, like you, Chris, am a bit concerned very concerned that this referendum is going to fail, and we can't afford to have a failure on these kinds of questions. It would be terrible to have a divisive referendum, and as you say, win or lose, if it's close, it will be disastrous. I mean, it would be disastrous if it failed, but a close result, I think, would bring ongoing problems for the whole country going forward. So I've put my head above the parapet on this, I suppose, and looked for a solution, a more minimalist, smaller solution that might satisfy Indigenous Australians, and which I believe a lot of Australians, or most Australians, should be able to get behind.
What are the problems with the Garma provision?
Well, look, to put it colloquially, it's very big. And so as a lawyer, I would say it's very radical. It inserts an entirely new chapter in the Constitution. Now, we've never done that before. So that's quite an enormous thing, particularly in Australian constitutional law, because in constitutional law jurisprudence in Australia in particular, we've always been very concerned with what the judges call text and structure. And we have a very nicely structured constitution. It's very simple. And so structure is really important. We only have a handful of chapters, and so putting an entirely new chapter in is a really big deal. And so that's likely to not only have an impact in its own area, but start to infuse into other areas in terms of constitutional jurisprudence. But that's also likely to have an impact on the ground and at the coalface and in our polity. So it's a really, as Mr. French, a former Chief Justice, who is very much behind this proposal, and I think you'd say almost actively campaigning, he says it's a big idea, and it is a big idea. And so I'm a little bit surprised that the the academics, it's mostly academics, Indigenous and non-Indigenous, the academics who are behind this are so committed to it because they're very experienced people and very good lawyers, and they also know that it's very difficult historically to change the Constitution in Australia. So when I first saw this particular amendment, I was surprised because I knew that it was not only big in the Constitution, but it would be big for our society. It would change the way we did things, and I was surprised. I still am surprised that they're attempting something so significant.
Much of the concern seems to focus on two key aspects. If I could describe it as the scope of the voice, the fact that the jurisdiction would extend to just about anything, and in particular, the fact that it's not simply a voice to Parliament, but a voice to the executive branch of government as well. Now, is that the full extent of the problems? And if we address those two things, is this project salvageable?
Well, you're absolutely right. They are the two biggest problems with it. So most Australians at the moment, I think, believe that it's pretty much a symbolic proposition. I don't think ordinary middle Australia is engaging with it at all. They just know, if they do know about it at all, then they're sort of thinking it's something quite innocuous, and they're probably waiting to hear more. But the fact is that whilst it's described as giving Indigenous people a voice in things that matter to them, the way it's drafted and the wording that is used, that is on laws of general application that apply to everyone. Now, when I talk to friends, even lawyers actually who are engaged in it, a lot of people misunderstand it. They think it's just in respect of a voice in respect of laws that apply specifically to Indigenous people or special laws about Indigenous people, but that's not the case. It applies to all laws. Now, it may be that the voice won't be concerned with every law, although there's a suggestion that that would be part of the process down in Parliament House, that there would have to be a statement, an impact statement in respect of every law that went through the Parliament that dealt with Indigenous issues. But it's this, as you say, a huge jurisdiction or remit that is the principal problem. And the problem there is, of course, whilst Indigenous Australians will have things to say about laws that affect all of us, I think in practice that could lead to, down the track, a lot of resentment from ordinary people who are not terribly well off, and they're concerned about Indigenous people getting a special or unique or privileged voice on things that really concern them too. So that's the biggest problem. But you're also right in identifying that it's extended beyond what I believe was its sort of original intention. And when I say original, I mean since about 2017, when a referendum council looked at it. It's extended beyond special laws for Indigenous people to laws that apply to all of us. But they've also now tacked on the idea that the voice would apply to the executive government, so not just policies that ministers are dealing with, but all of the public service too. So in reality, what that means is you'd probably have some sort of an agency, a voice agency in every department, with some sort of mechanism for making sure that the voice sort of looks at all policies that are being developed, and if they have something to say about it, then they will, and they'll get engaged and enmeshed with that policy development. So that adds a huge amount of work for the voice to do. And so not only will there be a fairly significant bureaucracy associated with the voice itself and what is expected to be about 24 members of the voice that will assemble in Canberra and probably look quite a lot and act quite a lot like politicians. It won't they won't be just dealing with proposed laws, they'll be dealing with all aspects of government. So they'll have a big bureaucracy, but we'll need another even bigger bureaucracy, I think, in the Westminster repositories of power, which is the Parliament and the executive and the bureaucracy. We'll need another big bureaucracy dealing with issues raised by the voice, dealing with the advice given by the voice on all these policies. So that's why I say this is really big. It's a very, very ambitious idea, and that's why I think it will fail once that this idea is put to ordinary Australians. I think they'll just say, no, that sounds like it's too much.
How can this be solved? How can this be fixed? I know you've drafted an alternative proposal. What would that involve? Tell me a little bit about that alternative proposal.
Well, look, in Australia, we have, in Section 51 of the Constitution, it sets out many 39 heads of power, which set out the main powers of the Commonwealth Parliament. And in Section 51(26), there is a clause that says effectively that the Commonwealth Parliament shall have the power to make laws with respect to, and then there's a list. And one of those on the list is Section 51(26), and that says the people of any race for whom it is deemed necessary to make special laws. So that was amended in the 1967 referendum to take out a reference to Indigenous peoples, which seems a bit silly now that we're wanting to put something back in the Constitution to recognise Indigenous people, which is obviously a good idea. We're all on board with that. But that power is currently used to make special laws with respect to Indigenous people, and it's been used about 16 times since 1967. And the Indigenous people don't want that to go because the special laws that have been made by the Commonwealth, whether they're with respect to setting up Indigenous bodies or the intervention legislation that was made by the Howard government, for example, they want that to stay in place because the perception is that those laws benefit Indigenous people. So my idea is to provide for a small representative body and amend that power so that it recognises Indigenous people and refers, instead of people of any races, to Aboriginal and Torres Strait Islander peoples, and then on the end of it tack on a proviso that the laws would only be made after the Parliament has heard from or received representations from, it doesn't really matter what words you use, from a body which represents Indigenous people. So my idea is that you use the current races clause, turn it into a new, what we'd call an Aboriginal and Torres Strait Islander clause, beautify it if you like, use it to recognise and appropriately indicate what's being done anyway. I mean, when the Parliament does make laws for Indigenous peoples and specifically about them, of course, there's a lot of consultation that happens already, but this would formalise that and it would balance out the slightly disconcerting side of it, and that is that it's a power to make special laws with respect to Indigenous people, which is not such a great thing. I mean, we'd rather not have to make special laws for Indigenous people. So that's my solution. And the reason I like it is it's tucked away. Well, firstly, it's in Chapter 1, so it clearly is just dealing with the Parliament. So it's definitely a voice to Parliament, but it's tucked away in this special clause. So it really is limited to special laws. My solution does not mean that you could not call this body a voice. You can still make a law under that provision, which is as big a voice as you like. The government could still pass a law that it might pass were we to enact or to enshrine this much bigger voice, if they wanted to experiment with that. But the enshrinement that I proposed is smaller. But the nice thing about my clause, I think, is that it recognises and gives a substantive right, a substantive but small group right. And that would be unprecedented in a liberal democratic constitution, actually. So it would still be seen actually as quite a big deal, but it's much smaller, a much safer enshrinement, I believe, than the one that is on the table. And I should say also, I'm not the first one to come up with the idea of putting, recognising Indigenous people within Section 5126. I think Frank Brennan, he has another idea now, and it would, people should go and have a look at the paper that Frank has written about this, and also he's written a book about it. So, but he did have an idea that it should be based in the Races Clause some time ago. And there's also another clause that was drafted by Professor Anne Toomey in 2020, which places the solution in Section 5126. The problem is that since that time, the caravan has moved on, and everything, this thing has just, it's become bigger. It's got out of Chapter 1. It's now in its own very own chapter. And as you say, we have not only a voice to Parliament, but a voice to the executive on everything. And it's sort of, the whole chapter now is framed so that they're really providing for an Indigenous sort of arm of government, if you like. And that's not what I'm saying. It's effectively what some of the academics have said about their own model. And just to sort of put meat on that bone, Chris, Professor Appleby has, for instance, described the Garma Amendment as being a foundational institution of state. She said that it will provide an important reordering of the hierarchy of the state, and it will provide a form for the transformation in Australia's established constitutional institutions. So even on their own case, the supporters of the Garma Amendment sort of recognise that this is quite a big thing to put in the Constitution. And whilst those are words that ordinary Australians might, or some voters might struggle with, I feel quite certain that once the no case gets going, they'll find a way to make that proposition quite retail. And I mean, I think a lot of money is going to be thrown at the yes case, but I don't think any amount of money is going to persuade Middle Australia to insert something so significant and so changing for the Constitution and therefore for our society into the Constitution.
Tell me whether I've understood it correctly, but would your provision reduce or possibly eliminate the litigation risk confronting public servants and the constitutional risk of the High Court putting its own approach, putting its own spin, if you like, on something more elaborate?
Look, my approach would definitely significantly reduce any risk of litigation. Look, this sort of litigation lawyers' picnic type debate sort of happens in every single proposal that is ever put up, and even not involving the Constitution, but whether it's saying sorry for Indigenous peoples. And I think sometimes that can be overdone. I think constitutional conservatives just immediately go to that, and sometimes that is overdone. I think the debate around potential litigation is the heat's coming out of it, because I think what has happened with the Garma model architects, they've accepted that there could be and likely will be some constitutional litigation that arises out of it. So, and I guess it's a question then of how much. the thing about my clause is that the enshrinement, rather than any legislation that might emerge out of using special powers, the enshrinement is very limited. It's only in respect of these special laws. So you could only ever have litigation when by members of the Voice or the Voice if there was a perception that the Parliament hadn't listened to them. But the current draft of mine, I won't get into technicalities, but I've tried to avoid that by using the words proposed laws, which the High Court tends to accept as a signal that they shouldn't go there and that it's not justiciable. And so I think the litigation that could emerge under my clause is very, the amount would be very, very low. And there certainly could never be any floodgates litigation. And by that I mean mostly judicial review litigation under Section 75(5), because Section 75(5) only applies to executive decision making. So it pulls all of that out of prospect. So I think mine's pretty safe on that front.
So if the government this month makes significant changes along the lines of what you're suggesting, do you think this slide in support for the referendum could be reversed?
Look, that's a question I don't think anyone could answer. I don't think the government will come to a much more minimalist clause. They might pull, it's possible they'll pull the executive government out of it because there's been a lot of talk about that. But whilever they keep it in a separate chapter, and even if they pull executive action and policy making out of it, but still have a voice with respect to laws of general application, we're still going to have a very significant institution of state with enormous entrenched political power, if you like. How it plays out in laws will change and no doubt evolve down the track, but its proponents say that the thing that they do that will be a measure of its success is the amount of political power it has. So they're still putting something very big in the Constitution, even if they took out executive action. I'd be very surprised if they, yes, yeah. I'd be very surprised if they come back. I feel they're very committed to this kind of big model, but I could be wrong. Now, you asked, would that make a difference? Look, I talked to people on both sides of the fence in this debate. I still think Conservatives, they're very against group rights in liberal democratic constitutions, because a group right, I mean, there's a place for collectivism, of course, in every society, but the idea that you have it entrenched in a constitution is really antithetical, if you like, to a liberal democratic constitution where we sort of focus more on individual political rights and what have you, although we don't, strictly speaking, have those in our constitution. But the idea of entrenching a collective right is still seen as antithetical and problematic. So I still think you'd have something of a no campaign against it. And that's a reason why the Gama proponents might say, well, let's just crash through with this much more appealing model. It's much more appealing to them. To them, it sort of does the injustices, the lack of what they feel is a lack of hearing, a lack of understanding. They feel that it sort of operates better for them, and they feel that they need that voice across all laws. Of course, as I said, they could have it anyway, and in fact, as a practical matter, they do. Look, I would like to think that something small, like my proposal, that the current proponents for the big voice could get behind it, that would be terrific. Perhaps they might come halfway to where Frank Brennan is. His version, he still limits the voice to special laws, but his version is more modest than what is on the table, but not quite as modest as mine. So they might come to, say, something in the middle, perhaps. I'm a little bit more hopeful about that. But even then, I still think you're going to have a no campaign. And my concern is, because this has been sort of sitting there for more than 6 months now, and it's starting to lose traction, I'm concerned that it's still going to keep sliding away from the proponents. I hope not, but because a divisive referendum would be terrible.
I tend to agree, and that's a depressing but an appropriate note to finish on. We've been talking with Louise Clegg about the troubles confronting the coming referendum on an Indigenous voice to Parliament.
Thank you for having me, Chris.